Subcommittee on the Constitution and Civil Justice will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. I will begin by recognizing myself for an opening statement. We welcome all of you to the committee hearing today. Because protecting taxpayer dollars from waste, fraud, and abuse is a critical responsibility with which Congress is entrusted, it is important that from time to time we examine how the False Claims Act is working. It has been 6 years since the Judiciary Committee has held a hearing on the FCA, and in that time, 3 major legislative changes to the FCA have been enacted. So we've called today's hearing to examine areas in which the Act has been effective and potential areas in which reforms could be made to detect and prevent false claims in the future. The False Claims Act is the federal government's primary tool for combating fraud in federally funded programs. And the Act has proved to be a very successful tool. In each of the last 4 years, the government has recovered over $3 billion under the FCA. And since the significant 1986 amendments to the FCA, the federal government has recovered over $38 billion using the Act. The FCA has been used to combat false claims in several economic sectors, including defense, healthcare, pharmaceuticals, and finance. However, despite its success as it is currently structured and enforced, the FCA still fails to prevent massive losses of taxpayer dollars to waste, fraud, and abuse. According to a recent study by the General Accountability Office, over $100 billion in taxpayer money is lost each year to improper payments by the federal government. Thus, the government recovers only a fraction of what it loses to false claims every year. This is especially troubling considering Congress has amended the FCA 3 times in the past 5 years to expand its coverage and enhance the ability of the whistleblowers to bring suit. So the question occurs, how do we get more recoveries of taxpayer dollars out of the False Claims Act? Some experts who have studied the Act suggest that the answer is all about incentives and encouraging those best able to detect and prevent false claims, government contractors and government program beneficiaries themselves, to self-police and self-report potential FCA violations. The advice of these experts seems to make a great deal of common sense to me. However, as currently structured, the FCA provides very few incentives for federal government contractors and businesses that participate in federal government's programs to come forward and disclose their own violations. In other words, those with the best knowledge of waste, fraud, and abuse are not encouraged to self-police for violations and self-disclose violations if they in fact occur. This is because there is no economic advantage or incentive to do so. FCA violators who self-report generally receive the same exact penalties and face the same damages as those who are caught violating the Act and settle out of court with the government. This would seem to make little sense. Shouldn't those that come forward and self-disclose violations get better terms than violators who are caught essentially red-handed? The FCA has been successful because it has provided whistleblowers with tremendous financial incentives for uncovering and disclosing false claims. It seems very appropriate and logical that to complement the current incentives for whistleblowers in the Act with financial incentives for self-disclosure will uncover even more waste, fraud, and abuse of federal taxpayer money. We need to examine ways to give those that do business with the government meaningful incentives to detect wrongdoing and to self-report it to government and thus return to taxpayers more money than is currently recovered under the FCA. The Justice Department itself has acknowledged the limitations of the Act as it is currently written. According to the head of the division at GOJ charged with enforcing FCA, the Justice Department is, quote, well aware of the fact that litigation can only plausibly reach a fraction of the fraud committed against U.S. government programs, which likewise makes the prevention of fraud a more potent tool for protecting the interests of the United States than efforts to undo the damage of completed schemes. Litigation to recover the costs of fraud is a far inferior option to preventing the fraud in the first place. Now, I hope through this hearing we can begin to discuss ways to prevent violations of the False Claims Act from occurring in the first place. The federal government has benefited greatly from the increased accountability that has resulted from the False Claims Act and the invaluable aid it has received from False Claims Act whistleblowers. We must make sure, however, that we're doing everything that we can to detect and prevent even more false claims against our nation's hard-earned financial resources. And I look forward to the witness's testimony, and I would yield. Well, let's see, the ranking member is not here, so I'm not going to yield to him. How's that sound? And I look forward to hearing then from our witnesses. And we will now just thank the committee for being here. We have two very distinguished panel witnesses today, and I will begin by introducing the first panel witness. Our first witness is Senator Chuck Grassley, the ranking member on the Senate Judiciary Committee. Senator Grassley has served in the Iowa legislature and the U.S. House of Representatives before being elected to the Senate in 1980. In 1986, Senator Grassley authored significant amendments to the False Claims Act to empower whistleblowers to file suit on behalf of the federal government against those who falsely obtain taxpayer dollars. Senator Grassley has been a leader in combating waste, fraud, and abuse in federal government programs and protecting the rights of whistleblowers. I'm wondering now at this point if we might ask the ranking member of the full committee if he has any opening statement or any comments.
Thank you, Chairman. I do, and I thank you for your generosity. Senator Grassley, welcome, and to the members of our committee. I merely wanted to read a page or two of my remarks and put them in the record so that we don't detain the distinguished witness that we have today. The False Claims Act is a long-standing and vital tool for ferreting out fraud against the government and ultimately protecting taxpayer dollars. And since its enactment in 1986, amendments to this law, almost $39 billion have been recovered from those that defrauded the American people, including some large pharmaceutical companies, hospitals, and defense contractors. In fact, more than $3.8 billion was recovered in the fiscal year 2013 alone. While no system is perfect, though, this act has worked well, particularly in light of the amendments which were spearheaded by our distinguished witness who is with us today. These amendments revitalized the Act's key TAM provisions. The Act was further strengthened with clarifications to its liability provisions that were made in 2009. And thus, as we consider the state of the False Claims Act, we should keep the following points in mind. To begin with, key TAM actions are a critical component of the false claims enforcement scheme. And I think for the interests of brevity, I will ask permission to include the rest of my statement into the record and yield back the balance of my time. And thank the chairman.
And I thank the gentleman and would now like to recognize Senator Grassley. Senator Grassley, thank you for your gallant service to the country, and we are pleased to have you here today. And I want to make sure that microphone is on so we can hear you, sir.
Before I read my 5-minute statement, I would like to, first of all, I thought the green light was on. I'd like to thank you for responding to my request to come and testify. Thank you for doing that. The second thing I'd like to say, you gave a nice introduction to me. Thank you for that. Thirdly, I often speak about whistleblowers as being welcome within an organization, kind of like a skunk at a picnic. Now, I kind of feel that there's a lot of special interests in this town are going to consider me a skunk at this picnic. Thank you for allowing me to come here today to testify. Today happens to be National Whistleblower Appreciation Day. Whistleblower groups are meeting as we speak to honor some of their colleagues on the Hill for their support of whistleblowers who report waste and fraud. I'm wary when I hear the biggest violators of a fraud law hire people to talk about strengthening that law. Last fall, the Chamber of Commerce released a report on the False Claims Act. It claims the act, quote, plainly is not getting the job done, since the government has recovered only $35 billion since 1987. Now that figure is, as you folks have said, is 39, and some people use the term $42 billion. Anyway, this amount of money is nothing to sneeze at where I come from in rural Iowa. The fact is that since 1986, no other law has been more effective in battling fraud, and you said that, Mr. Chairman, in your opening statement. Before the 1986 amendments, it only brought in about $40 million a year, not billions of dollars. At that rate, it would have recovered only $1 billion in the past 25 years. Thanks to these 86 amendments, it's brought in 39, 40 times that amount of money. Clearly, the False Claims Act is working, and it's working fantastically. The report that I previously referred to says that the law is, quote, ineffective in preventing fraud, end of quote. Yet my staff have met with some of the authors of that report, and they don't have any concrete proposal for preventing fraud more effectively. They talk about a gold, quote, a gold standard compliance certification program, end of quote. But that just happens to be a pie-in-sky idea with no specifics. As they said, quote, we had to come up with something, so we just put that in, end of quote. The Chamber clarified to my staff that they were talking about their proposal for internal reporting 180 days before any whistleblower can file a false claims suit. Yet they also said of the overall certification program, quote, we deliberately left this vague. Now, that's a very serious problem. They lack details on who would create the program, who would enforce the program. Basically, everything about it lacks detail. But they want you to believe that once this pipe dream is in place, it will magically increase the amount of taxpayer dollars the government recovers. In exchange, the report proposes hefty concessions for its big corporate sponsors. For starters, they want to eliminate the use of exclusion or debarment, some of the government's strongest tools on deterring fraud. They would require whistleblowers to report internally, which just puts a huge target on the back of a whistleblower. Internal reporting and a 6-month head start on retaliation before a whistleblower gets a chance to be heard in court is a recipe guaranteed to reduce disclosures of fraud. Even when a corporation does come forward, the company line is never going to be the complete picture. That's why the False Claims Act incentivizes whistleblowers, and you see how it has worked. While I believe companies should have strong internal compliance programs, nothing is worth the get out of the jail free pass that this report asks in exchange. Many corporate giants already spend large amounts on compliance, but still routinely bilk the government out of millions of taxpayers' dollars. This report's recommendations contradict its assertion that the False Claims Act has failed by not recovering enough money. The report proposes to limit government recoveries across the board, regardless of the participation in any compliance certification program. That just makes no sense. In the last 5 years, the federal government has grown larger and larger, and spending has gotten more and more out of control. Whistleblowers using the False Claims Act have played a key role in checking fraud and wasteful spending. Sure. Annual recoveries under the False Claims Act have increased dramatically in the last 5 years. State attorneys general around the country have used state False Claims Act to successfully recover billions of dollars for their states. For example, last October, then Virginia Attorney General Ken Cuccinelli recovered $37 million for the state of Virginia from a drug company that was inflating its prices to scam taxpayers' dollars from Medicare. The next month, Cuccinelli recovered $21 million in 2 healthcare fraud settlements with multinational pharmaceutical giant Johnson & Johnson, which was paying millions of dollars in kickbacks to the nation's largest pharmacy. Yet, just days before Cuccinelli's announcement of the settlement, Health and Human Services Secretary Kathleen Sebelius also made an announcement. She revealed that this administration did not intend to treat the Affordable Care Act as a federal health care program, then exempting it from anti-kickback laws, precisely because of the fraud opportunities under the Affordable Care Act. One provision that Congress added to the law made a violation of the anti-kickback law and an automatic violation of the False Claims Act. This administration has chosen to ignore that part of the law. Congress must step forward, and we must reiterate that the Affordable Care Act is no less subject to the anti-kickback law and the False Claims Act than any other federal health care programs. Additionally, this subcommittee should strongly consider strengthening the False Claims Act's connection with suspension and debarment. That would keep repeat offenders away from taxpayers' dollars. A couple years ago, the Nonpartisan Government Accountability Office discovered serious weaknesses in the suspension and debarment program of numerous government agencies. Chairman Issa and Ranking Member Cummings of the House Oversight Committee have joined together with some proposals on this issue. Chairman Issa stated last fall, quote, "The current process of keeping taxpayers' dollars out of the hands of criminals, tax evaders, and the chronically incompetent is stovepiped, fractured, and inadequate," end of quote. This issue is really about law and order. If we really want to improve the False Claims Act, we should make a judgment or settlement under the law result in an automatic review for suspension or debarment. That would capitalize on the success of the law while increasing its deterrent effect. The False Claims Act has already provided a crucial check during a time of growing government and out-of-control spending. No matter what we do to deter waste and fraud, whistleblowers are the key to the government finding out when that act happens. Today, on National Whistleblower Appreciation Day, I hope we can honor whistleblowers for the patriotic service that they provide to the taxpayers. Thank you very much.
Well, thank you, Senator Grassley. And again, we want to express our gratitude for you making the trip over here and the cogency of your remarks. Thank you very much, sir. I would now like to turn to the second group of witnesses, if you'd like to take your seats. Our first witness on this panel is Dr. Rashakundo Prabhu. I'm going to try that again, sir. Rashakundo Prabhu. No, nobody ever has any trouble with that name, do they? All right, sir. And Dr. Prabhu is a board-certified pulmonologist. Boy, I'm having trouble today. Pulmonologist and the founder of Red Rock Medical Group, the largest specialty medical group, multi-specialty medical group in the state of Nevada. He's also a clinical associate associate professor of medicine at the University of Nevada School of Medicine. Dr. Prabhu is was twice sued under the False Claims Act, and both times at great personal expense prevailed in the litigation. In one of the cases against him, the court determined that the case brought by the government was without substantial justification. Our second witness is Patricia Harned. Got that one, huh? President of the Ethics Resource Center, the nation's oldest nonprofit organization devoted to the advancement of high ethical standards and practices in public and private institutions. She serves as consultant to the New York Stock Exchange and is a member of good standing of the advisor group of the Public Company Accounting Oversight Board. Dr. Harned has testified before Congress and the Federal Sentencing Commission and has been featured in media outlets including the Wall Street Journal, Washington Post, and USA Today. Our third witness is John Clark. John, thank you for having a simple name. An attorney specializing in False Claims Act litigation. Mr. Clark is testifying today on behalf of Taxpayers United, Taxpayers Against Fraud. He has served as an attorney in the Justice Department's Criminal Division, as an assistant U.S. attorney, and as the U.S. attorney for the Western District of Texas. Mr. Clark has been a member of legal teams representing whistleblowers in cases that have resulted in recoveries totaling more than $3 billion for the United States and state Medicare, Medicaid programs. Our final witness is David Ogden, a partner at Wilmer Hale. He is testifying on behalf of the Chamber of Commerce's Institute for Legal Reform. Mr. Ogden has held several positions at the Justice Department, including serving as the Deputy Attorney General of the United States from 2009 to 2010, and as Assistant Attorney General for the Civil Division from 1999 to 2001. As head of the Civil Division, he directed the Justice Department's False Claims Act enforcement. Now, each of the witnesses' written testimony will be entered into its record in its entirety, and I would ask each witness to summarize his or her testimony in 5 minutes or less, and to help you stay within that time, there's a timing light in front of you. The light will switch from green to yellow, indicating that you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. And before I recognize the witnesses, it is the tradition of the subcommittee that they be sworn, so if you would please stand to be sworn. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Let the record reflect that the witnesses answered in the affirmative. I will now recognize our first witness. Dr. Prabhu, please turn on your microphone, sir, before you begin.
Thank you, Chairman Branch, for inviting me to testify, and Honorable Congressman Mr. Conyers, Honorable Mr. DeSantis. I'm a doctor who has been practicing medicine in Nevada since 1979. I've been sued twice under the False Claims Act. Both times, the actions were dismissed, and I was exonerated. But the lawsuits were ordeals that had a terrible effect on my medical practice, my finances, my health, my family, and my reputation. Over 10 years, my wife and I had built up a good medical practice with several doctors and employees. In the 1990s, 3 former employees made a false accusations against me in a key term lawsuit. Then they persuaded the Department of Justice to join the lawsuit in 1999, and my life turned upside down. They fabricated charges that I had performed unnecessary medical tests and used the wrong billing codes. These allegations were not true, but that did not stop the press from printing them. I was a doctor with tremendous reputation, a teacher, a humanitarian, and the next day, my reputation was tarnished. My medical practice went down. My wife and I had to work without taking any salary. The doctors left, and we had to let employees go. I was also emotionally destroyed. It was hard for me to get up in the morning, to face people giving you dirty looks in the hospitals. The stress took a toll on me physically, and I developed medical problems. Worst of all, my kids were little, and because of the press, other kids would tease them and make them cry. They would tell me, "Dad, we don't want to go to school." But I never considered giving up or settling, even though the government was asking me for millions of dollars for things I had not done. I also knew the government could kick me out of Medicare and Medicaid. After many years, I was finally proven right. The government dropped out of the key term lawsuit because it found the allegations were untrue. Eventually, the judge dismissed the entire lawsuit. Although I was vindicated, the financial cost to defend myself was incredible. The total expense was between $4 to $5 million. Almost all of the money we had made was gone. After the lawsuit ended, I tried to gain my reputation back and build my medical practice. After several years, we had grown up to 30 doctors and over 100 employees. One of the services I have been providing to my patient with advanced lung disease is known as pulmonary rehabilitation service. Patients would come to our office and we would exercise them under supervision. When I first started providing this service, there was no Medicare code, so I was doing it for free. Later, I was told that it was improper under Medicare rules to do anything for free. So we asked Medicare, what should we do? A Medicare representative came to our office and told us the billing code that we have to use. And we used that code for 20 years, and our Medicare carrier assured us it was the right code to use. Then, in 2004, we learned the US Attorney's Office was investigating our use of this code. I met with the US Attorney, but he didn't listen. One afternoon, a reporter called and said, Dr. Prabhu, do you know the government filed a false claims lawsuit against you? The nightmare started all over again. My medical practice collapsed. Doctors started to leave. We had to let our employees go. We even had to close a clinic in nearby town that badly needed our doctors. I was so depressed. This time, the government told me that under the False Claims Act, I would have to pay $22 million. They said we had billed Medicare for 2,000 tests over 6 years, and they wanted a penalty of $11,000 for every test, which came to $22 million. But we only charged $50 for one test, and we had charged only a few $100,000 for all the tests. In the process, we even lost money. It just made no sense. But I knew the government could kick me out of Medicare and Medicaid, and I would lose my livelihood. I know that in many cases, doctors simply settle when they have to go through what I have gone through. Some lose their professions, their spouses, their children, their houses, their health, and some even commit suicide. But I refuse to give in. Once again, I hired a team of lawyers and experts. In the end, the government's case fell apart, and the judge dismissed the case. The lawsuit was so unjustified that we filed a motion to recover legal costs. The judge awarded me $500,000 in attorney's fees, but I still spent over $2 million to defend myself. In conclusion, I went through this ordeal twice. I spent more than $6 million to defend myself. I twice lost my practice, my friends, my partners, my dreams, and my reputation. The False Claim Act should be more fair so that it cannot be used to bankrupt people when they have done nothing wrong. I don't want what happened to me to happen to other citizens of this great country. Thank you.
Well, thank you, Dr. Prabhu. We'll now recognize our second witness, Dr. Harned, and please turn on your microphone if you would, Dr. Harned.
Good afternoon, Chairman Franks, Ranking Member Cohen, and members of the subcommittee. Thank you for the opportunity to testify today. I'm president of the Ethics Resource Center, America's oldest nonprofit dedicated to independent research on workplace ethics. Our center generates the U.S. benchmark on business ethics known as the National Business Ethics Survey. We also consult with companies to assess their ethics and compliance programs and cultures. And finally, ERC educates public officials on new insights coming from our research. For example, very recently, we've shared our work with the OIG from the Department of Justice. from the Department of Housing and Urban Development, and also the Interagency Suspension and Debarment Committee. It's important to note that while ERC's research was cited in the report that's been the impetus for today's hearing, our center was not involved in the writing of the report itself. Neither am I an expert on the False Claims Act. The views I express today are based on the objective findings from ERC's research. A central focus in today's discussion is the proposal for accrediting rigorous compliance programs. So I'd like to address a few questions that are fundamental to that proposal. For example, if a company has invested in an ethics and compliance program that actually works, can we expect that the number of instances of fraud will go down? When fraud does occur, will the reporting of violations go up? And finally, if standards are established to define state-of-the-art programs, is there evidence that industry practices will improve? First and foremost, ERC has found that when an ethics and compliance program is well implemented within a corporation, there is demonstrable impact on the conduct of its employees. Employees in companies with well-implemented ethics and compliance programs are more likely to say that they work in strong ethics cultures. And when a strong program and a strong culture are in place, misconduct decreases by more than half. Similarly, in organizations with strong programs and cultures, the potential for wrongdoing is lessened. 44% fewer employees in companies with strong programs say they feel pressured to break the law in order to do their jobs. And in the same vein, 90% of employees in those kinds of organizations with strong programs and cultures say they know how to appropriately handle wrongdoing if it were to arise. And importantly, when wrongdoing does occur, the rate at which employees step forward to report increases by 94%. In 2013, more than 1 in 5 U.S. business employees said that they observed at least one incident that might be considered a False Claims Act violation. That percentage dropped by 71% when employees said they worked in a strong ethics culture. Yet you could ask, if ethics and compliance programs have such a significant impact on business conduct, why does fraud continue to occur? Part of the reason is that misconduct is a reality in every corporation and in every organization, for that matter. But it's also the case that as of 2011, only 1/4 of U.S. employees said that their company had a compliance program that was well implemented, meaning that it had all of the elements in place that we know improve and encourage ethical conduct. And that's where a certification process has the potential to play an important role. Standards for certification or the like do shift corporate behavior, provided the entity establishing the standards is trustworthy and free from conflicts of interest. Standards are established with significant input from industry leaders and enforcement officials. The criteria take into account differences in organizational size, industry, and the context in which an organization is operating. And the standards are living and breathing, meaning they evolve with new insights from research and practice. Finally, and perhaps most importantly, it's imperative that any definition of an effective program focus on compliance, but also ethics. Companies that merely comply with the law check the box when they've met expectations and move on to other priorities. And that's the danger of a certification standard without the dimension of ethics. It's the commitment to ethics and culture that perpetuates right conduct in a company and diminishes the need for enforcement due to violations of the False Claims Act. Thank you again for the opportunity to address you today. I welcome your questions.
Mr. Ogden, we'll get back to you. Now recognize our third witness, Mr. Clark, and if you turn on your microphone, sir.
Can't tell when it's on. Is it on? Thank you, Mr. Chairman. I appreciate the opportunity to express my views on this important law. It has enjoyed overwhelming bipartisan support for 28 years now. I come from a small firm of 9 lawyers. 2 of us represent whistleblowers. The other 7 are busy with things like real estate transactions and municipal law and insurance defense litigation. Representing whistleblowers is the most professionally satisfying thing I've done since I was the U.S. Attorney in Texas, investigating and prosecuting corrupt public officials in a historically corrupt Texas county. We live in an era of ever-growing government and ever-proliferating programs that spend mind-boggling sums of taxpayer money. Big industry groups love big government programs because they have all that money to spend. And we have a resulting phenomenon that I call the Washington merry-go-round. Others call it crony capitalism. Bright, able people get on the merry-go-round and they enter government service, mostly as administrators or lawyers. They make policy, administer programs, deal with legal issues. They are regulators and they learn how the government works from the inside. Later, the same government officials get off the merry-go-round and they're eagerly recruited by industry groups as counsel or as lobbyists or both. They become part of the community that they used to regulate, and now the regulated industry group's interests are their interests to protect. One of their goals is to undermine incentives for whistleblowers who take risks when exposing fraud. The goal of the former regulator, now an industry lobbyist, is to make it more difficult for the government to succeed in making False Claims Act cases against their clients' interests. The Department of Justice does a lot with limited resources. They work hard to enforce the False Claims Act and recover America's stolen billions. One way the False Claims Act might be amended to help the Department of Justice, and it could be accomplished without cost, is to embrace a provision that we now find in 15 of the 29 state False Claims Acts. Under those 15 state False Claims Acts, the state can recover its attorney's fees in a successful case. The United States should have the same right, but that's a right that is now lacking under the Federal False Claims Act. Those fees and a percentage of all False Claims Act recoveries should be specifically allocated to funding False Claims Act enforcement. I suggest we should also add tax fraud enforcement to the False Claims Act. The IRS now has a whistleblower incentive program, but that program is not working. But again, the states provide a working model that the federal government might copy. New York has added taxes to its False Claims Act, and it's already recovering millions of dollars. And one more thing. Just as no company should be too big to fail, no individual should be too important to incur personal consequences for fraud against the government. Personal consequences are a strong deterrent to fraud. Let me conclude by saying I am struck by the wisdom of Senator Grassley's skepticism and caution about buying into a fanciful, untested, gold-plated certified compliance program. The key to compliance is integrity. It's not just a matter of paperwork as evidenced by the multiple offenders under the False Claims Act. Justice Oliver Wendell Holmes said it best for all of us, and in just 11 words, when he wrote for the court in U.S. versus Rock Island Central Railroad in 1920. He said, "Men must turn square corners when they deal with the government." Thank you, Mr. Chairman.
And thank you, Mr. Clark. And now we'll recognize our fourth witness, Mr. Ogden. And sir, if you make sure that microphone's on.
Thank you, Mr. Chairman.
Thank you, sir.
Am I okay? Great. Thank you, Chairman Franks, Ranking Member Cohen, and members of the committee. I appreciate the opportunity to appear before the subcommittee today to testify on this important issue. The False Claims Act has been a focus of both my government service and my private practice for over 15 years now. And so I know from direct experience in both places that its unique provisions play a catalytic role in unearthing evidence of fraud and in recovering monies lost to fraud. But there is no doubt, and we've heard some of them today from Dr. Prabhu, there are costs, harmful and counterproductive effects of the law as well. I believe in the False Claims Act, and indeed as Assistant Attorney General, I personally defended the constitutionality of its critical QI-TAM provisions before an en banc Court of Appeals, and as Deputy Attorney General, I helped implement and design the HEAT program, which has effectively addressed hardcore fraud in the healthcare industry. But I also believe that we have a real opportunity to enhance the Act's effectiveness and fairness while using it more effectively to prevent fraud before it occurs, as you, Mr. Chairman, identified as a goal, an important goal. Now, I start with 4 basic points. First, the FCA helps uncover fraud against the United States and helps return ill-gotten gains to the federal government. Those functions should be preserved and enhanced, and nobody is suggesting otherwise. Second, encouraging whistleblowers with valid concerns to come forward is critical to the Act, and that is a very good thing. Indeed, I believe the Act can do much more to encourage and protect legitimate internal whistleblowers by incentivizing companies to do more of that themselves. I heard and understand Senator Grassley's concerns, and to be clear, we strongly support the function of whistleblowers and the role the FCA has played in incentivizing them to come forward. Third, however, at the present time, the Act is generating a stampede of weak and frivolous claims, we heard about a couple of them earlier, that unproductively burden the government, the courts, private businesses, and individuals alike. And fourth, the Act is construed by the courts, often mandates punishments so far in excess of any real-world harm that defendants are often deprived of meaningful access to the courts to test the most aggressive theories of liability, because settlement for many businesses in that situation is effectively the only option. Dr. Prabhu identified some of the ways in which that works, where these potential penalties so far exceed the consequences of at issue. Now, I discuss in my written testimony the way these virtues and vices are caused by the FCA's unique features that make it entirely different from other enforcement schemes and call for, I think, some intelligent adjustments. Now, as outlined in my testimony, I believe there is a sensible way forward, one that aligns government and business alike to prioritize preventing fraud before it diverts federal dollars from their intended uses, truly making compliance the first line of defense. First and foremost, we should be encouraging and incentivizing all companies to implement and maintain state-of-the-art compliance programs. Programs that promote the highest levels of corporate ethics and legal compliance, encourage and protect internal whistleblowers, and voluntarily report any violation promptly to government authorities. Dr. Harnett has talked about how that works. Now, under reforms I helped develop for the U.S. Chamber of Commerce and its Institute for Legal Reform, certain rules would apply differently to entities that have been independently certified as maintaining state-of-the-art compliance programs, including the strongest protections for whistleblowers consistent with standards approved by the government. These proposed reforms were the product of my years of work thinking about the Act and the good ideas of my co-authors. We put pen to paper after months of discussion and consideration, eventually producing the white paper, Fixing the False Claims Act. Our compliance-based approach is not, with all due respect, pie in the sky. Dr. Harnett's research shows that state-of-the-art compliance systems work. They reduce fraud, they encourage and protect whistleblowers, and they result in prompt self-disclosure of violations to the government. And so what we propose are incentives for companies and whistleblowers to do these things. The proposed adjustments would by no means remove deterrence and jeopardy associated with Civil False Claims Act liability. They would do nothing to change the criminal penalties for individual accountability that were talked about earlier, but they would create differences sufficient to incentivize the adoption of first-rate compliance programs by recognizing their significance in assessing any entity's culpability and recidivism risk. These reforms are designed to incentivize individual employees to report wrongdoing internally, and companies to act quickly to identify and halt wrongdoing and report it to the authorities. They are also designed to make the potential consequences more proportionate to the circumstances, including taking into account whether an entity has programs in place to prevent fraud. There's every reason to believe that increased self-policing and voluntary disclosure that these reforms would encourage will mean less fraud, less harm, and less need for lawsuits. There's more detail in my written statement, Mr. Chairman. I appreciate the time and welcome your questions.
Well, I thank all the witnesses. We're told that they may call votes any moment, and that'll give us a short period of time to respond. But if we proceed with questions quickly, we might actually get past this and not have to hold all of you over here. If we can do that, we will. So, Dr. Harnett, I'll begin with you. It seems sort of counterintuitive that we should attempt to rely on the perpetrators of False Claims Act violations to self-report when they violate the Act. Can you explain to me how it would be reasonable to expect businesses to detect and report their own violations of the FCA to the federal government?
Thank you, Mr. Chairman. One of the things that we have seen in our research as we've looked at different kinds of organizations and what motivates them to implement ethics and compliance programs It is the case that the majority of companies want to implement very good programs because it is a preventative measure for themselves. The majority of companies that have good programs and strong cultures in place have leaders that are very committed to ethical conduct. They want to avoid overstepping the law, and that's why those programs are very effective. So it's not so much a case of the perpetrators monitoring themselves so much as it is the case that most companies that are implementing these good programs are doing it for all the right reasons.
Right. Mr. Clark, I might ask you, do you think that the efforts that have been discussed related to trying to get self-compliance by these companies could bring harm to the existing protocol? It shouldn't be rocket science, but they make it hard on everybody, so don't feel bad. I'm thinking about just getting some megaphones.
Mr. Chairman, compliance programs are fine. I certainly have no quarrel with compliance programs, but we have seen that quite a number of entities that have resolved False Claims Act cases, which means that they entered into a corporate integrity agreement, and that required a strong compliance program, went right back to the same pole and were lapping at it again. I think compliance programs certainly can help, but if a company plastered Justice Holmes's admonition over their entrance as their motto and lived up to it, that would help more than anything else. Integrity is the key, and law enforcement, which is my background, is what enforces that.
Mr. Ogden, you had suggested that that there was clear evidence that these compliance programs could work, and I know you've authored some programs in that vein. Can you tell us what just would be the top, even anecdotal or clear evidence that you would report that would indicate that these programs do work and don't harm the private whistleblower enforcement?
Absolutely, Mr. Chairman. I think Dr. Harned's work for the Ethics Resource Center is extremely strong support for the proposition that these programs work. As she says, no program can entirely eliminate wrongdoing in any institution. The key is to have measures in place, and as Dr. Harned says, we know what these measures are that are working well. Have measures in place at a company that make clear that Justice Holmes' admonition is the rule of the day there, that empower employees to come forward, encourage them to, make clear to them they're going to be protected, make clear that when they report wrongdoing, it will be taken seriously, investigated, and where valid, reported, and that there's prompt reporting. We know these systems work, and where they're in place.
You say we know these systems work. What evidence would you cite just briefly?
I would really rely first on the evidence that Dr. Harned has put forward, the research of the Ethics Resource Council.
All right, well, listen, I'm going to yield to the ranking member of the committee for 5 minutes where we might actually beat the vote here.
Thank you, Mr. Chair, and I apologize for my coming in a little late. Sorry I missed Senator Grassley's. I've read his testimony, and it was certainly compelling, and I commend him for the work he's done on this issue. These False Claims Acts have been responsible since 1987 of bringing in $39 billion in recoveries from corporations that cheated the American taxpayer, according to the Justice Department, and $27 billion came from Keaton plaintiffs. So it seems like a lot of money we're talking about, and we're talking about concern with the budget deficit. We'd be giving up a lot of money that's involved, and money is an effective way of seeing that people do comply with the law, and Senator Grassley is to be commended for his work in bringing this to the fore. I would like to ask Mr. Clark, and I appreciate your testimony. Mr. Ogden suggests that his reforms are sufficient to correct the injustices that he sees and yet keep the program strong. Do you believe if we adopt the amendments that have been proposed here and that Mr. Ogden endorses, and I presume Dr. Harned does as well, that the Keaton law and the False Claims Act will remain a strong deterrent to government fraud?
Sir, I do not think so. I think they would have two effects, or maybe one effect and one non-effect. I am skeptical about the degree of help that some kind of reliance on a compliance program would bring. But I'm also cognizant that whistleblowers and the council who represent them have to make tremendous investments of time. The whistleblower has to take a big risk to come forward, big risk of retaliation, and some of these proposals would increase the whistleblower's risk and diminish the whistleblower's incentive to go forward. These cases can take, I spend months and months and months sometimes after I interview a client, deciding whether the client is a reliable and trustworthy and straightforward person, investigating for myself as best I can to find out what the facts are. I invest, any qui tam lawyer does, months of time, often, and lots of money to investigate these cases. To diminish the incentives, which some of these things would do, I think would be a step backward.
I missed most of the testimony of the doctor, even though I read some of it, and I just wonder, Mr. Clark, if there were oversteps or improprieties by the attorneys in an action against an individual, as I guess the doctor suggests there might have been in his case, does not Rule 11 bring an adequate and appropriate sanction against an attorney for pursuing a claim that's not appropriate?
There are several rules and several entities that hold sanctions for things like that. A lawyer who files a frivolous case, first of all, is going to be in trouble with the federal judge in whose court the case was filed. Federal judges have no patience with frivolous lawsuits. The statute allows the defendant, like the doctor, to recover his attorney's fees. And Rule 11 applies, and the attorney would also be in trouble with his bar association. He might lose his license over something like that.
Thank you, sir. Dr. Harnett, your group is, what's the name of your group? Ethics?
The Ethics Resource Center.
Who are the major funders of the Ethics Resource Center?
About 95% of our funding comes from the private sector, not for lack of trying to see if we can get public support for our work. The companies that invest in us, they tend to do it for one of three reasons. They ask for our help in assessing their ethics and compliance programs, or they're a part of a fellows program that we have for chief ethics and compliance officers along with academics and government officials. And then a portion of our funding comes for research to do the work that we do through the National Business Ethics Survey and other studies.
And you are an attorney, or are you not?
No, I'm not.
You're not, okay, I see. Mr. Ogden, you are, I know, and you've got a distinguished career. Have you ever brought any actions on behalf of whistleblowers?
I have not brought actions as a private lawyer on behalf of whistleblowers, Congressman Cohen. I have brought in a number of actions as a public official, intervening in actions brought by whistleblowers on behalf of the United States and pursuing their claims. And as I mentioned, as Assistant Attorney General, I defended the constitutionality of the act that gives whistleblowers the right to bring these claims.
I mean, Senator Grassley said that your proposal for a gold standard compliance certification program was, quote, pie-in-the-sky ideas with no specifics, and that it's, quote, a pipe dream, unquote, to suggest such a program would magically increase the amount of taxpayer dollars the government recovers. The senator also said that his staff was told by the chamber regarding the proposal for a compliance certification program that, quote, we had to come up with something, so we just put it in. How do you respond to Senator Grassley on those assertions?
Well, thank you, Congressman. I have the highest respect for Senator Grassley and what he's done with this statute. What we're trying to do is build on that statute. With respect to the pie-in-the-sky idea, as I said, effective compliance programs that protect and encourage internal whistleblowers, companies that have fine ethics cultures and report violations to the government, that's not pie in the sky as the work that Dr. Harden and her group has done and shows. The fact is good companies do try very hard to comply with the law, and we can encourage them, we can set standards, we can encourage more companies to perform that way. As far as the Senator Grassley's report of his staff's comment, I wasn't present for the meeting that was had with his staff, but I can tell you, we didn't just put this forward and just come up with something. I've spent a lot of time on this statute. I have a great belief in it. I believe in whistleblowers. I believe in the incentives of the Act, but I think it does a lot of harm. And it does harm in the ways we've described. And Dr. Prabhu's not the only one. The Act can be improved, and we're suggesting some very structured ways. They're not going to interfere with the Act's effectiveness, but they are going to ameliorate some of these effects.
I want to thank you and everybody else as an outstanding panel of outstanding. And I'd like to ask for unanimous consent to allow my opening, which has become my midterm statement, to be put in the record.
Without objection.
Thank you.
Mr. DeSantis.
Thank you, Mr. Chairman. Dr. Prabhu, what happened to your patients when you had these False Claims Act filed against you?
Well, my patients were very sick, and they had a lung transplant or a lung volume reduction surgery, after which they would come back to our office for, specialized structured pulmonary rehabilitation program. After I was forced to shut it down, I had to send my patients to outside facilities, which are just not as good. As a matter of fact, 2 of my patients died. And I also had to stop going to a clinic we had in Pahrump, town of Pahrump, which was very understaffed, and they needed us to help them out.
Now, are you just against, you're not against whistleblowers generally, you just think that this statute can lead to bad consequences for innocent people. Is that your correct position?
Well, I'm basically here to tell you my story and what happened to me.
Right.
Just based on my experience, if those 3 people, my employees, came to me and told me what problems they detected, I would have addressed it right away, and the government wouldn't have lost so many millions of dollars, and I wouldn't have lost millions of dollars.
Now, what were your litigation costs in dealing with these 2 claims?
$6 million.
Okay, and were you able to recover any of those costs?
Well, the second case was so unjustified, so we were able to file a motion to recover attorney cost, but the judge only gave us $500,000 out of $6 million I have spent.
So you got a judgment for $500,000. Have you actually been able to collect that money?
Yes, the government paid us a check.
Okay, so they have given it to you?
Yes.
Okay. So you actually won your cases, basically, but it doesn't seem like those were victories.
Well, I wouldn't call it victory. My life is ruined. I can't get all the time back that I have lost in the, last 20 years, one case after the other. My reputation is damaged. A lot of things I wanted to do in life. I was doing medical research, working with lung volume reduction surgery. I was advancing in my profession. We were taking care of a large number of patients. And, I had some political ambitions, and nothing was possible.
So basically, this detracted from your ability to help sick people?
Yes.
How did the civil penalties and damages the government sought from you compare to the actual amount of money you received that allegedly violated the False Claims Act? That's
so absurd. They basically said, every time I submit an invoice and get paid I get $50, they wanted me to pay them back $11,000. They calculated that over 6 years, I submitted the code 2,000 times. They said I had to pay them $22 million.
Wow. Mr. Clark, I guess the criticism I've heard about kind of how this operates in practice is that 90% of the cases in which the U.S. doesn't ultimately intervene when individuals are bringing the key TAM cases, that they're just abandoned or dismissed. So how would you address, is that a misallocation of resources, that cases that once the government makes a decision are going to kind of wither on the vine, or do you think that everything should continue to go the way it's going?
Well, I think there are a number of reasons.
I think it's on. Not now.
Tell from here.
Leave it. Okay.
I think there are a number of reasons why, in the first place, why the Department of Justice declines cases. Part of it is a lack of resources. They have to prioritize what they're going to do because of the resources they have to do it with. I'm sure that they concentrate first on the cases that look like they're going to be the biggest to intervene in. So whenever they decline one, they write a letter to the court and to everybody concerned not to take this as an indication of the merit of the case. They've declined it, and they don't have to state their reasons.
But is that in fact happening, though, given the statistics that it's over 90%?
I would say it probably is. I don't know. I don't have the statistics on that. I don't know that there's any that they're published any place. A lot of them are declined. Probably three out of 4 anyway are. But why they don't go forward could be any one of a number of reasons. The Department of Justice may have discovered something in doing its due diligence survey of the case after it's filed during the period it's under seal that makes it clear that the case is not going to succeed for one reason or another. And that may be apparent to the attorney who filed the case after justice declines it. Second, going forward with a False Claims Act case against a Fortune 500 company when you're a 9-man law firm that has 2 lawyers who do False Claims Act work is not an enticing prospect. And the client has to be apprised of that, and the client has to make the decision, do you want to continue to fight this thing? Here's what it's going to entail, because it takes years to get one of these cases litigated.
Great. I'm out of time. Thank the witnesses. I appreciate your comments. I yield back.
And I thank the gentleman, and I would now recognize Mr. Conyers, the distinguished ranking member of the full committee.
Thank you, Chairman Franks, and I thank the witnesses. I'd like to have someone explain why the False Claim Act's penalties that allow for treble damages and additional penalties for each violation is important. And let me just start with you, Mr. John Clark, and then I'll ask at least 2 of the witnesses the same question. Please.
Thank you, Mr. Conyers.
Is your mic on? It is. Pull it up closer then.
Thank you, sir. Both damages and penalties are important as deterrents.
Mm-hmm.
Penalties are not sought in all cases. Penalties are sought in some cases, the egregious cases. And there are constitutional limits on the amount that can be assessed in a False Claims Act case. The Eighth Amendment protects someone from excessive penalties. But they are important because they can be invoked, and when they are invoked, then they are a powerful deterrent. They're not invoked in all cases. They are there. That's a tool that the government can use if it chooses, and if the court agrees with it, but they're not assessed in all cases.
So they're not made, it isn't that they're identified at the beginning of the case. It's after a determination and a conviction has been arrived at. Is that the case?
That's correct.
Mm-hmm. So do you think that they are excessive, or that they are used in a way that is not beneficial for us protecting the government against false claims and fraud?
Sir, I think penalties should remain as a deterrent, and they're, as I say, they're not always imposed, particularly if the case is settled, they're not going to be imposed, typically.
Mm-hmm. Mr. Ogden, do you share approximately the same view?
I don't, Ranking Member Conyers, and thank you for asking. First of all, it is required under the statute that in a case that goes to judgment, these civil monetary penalties be imposed in addition to treble damages, so that we have not only the treble damages required under the statute, as under antitrust law, for example, but in addition to that, there's a requirement that for every so-called claim between $5,500 and $11,000 be assessed. That's what's required if you go to judgment. It's simply not true that they're not applied in every case. They're applied in every case that goes to judgment. And as Dr. Prabhu said, it is for that reason possible for you to have merely a couple $100,000 in his case of business with the government. The total possible damage the government would have suffered in his case, if he had done anything wrong, which he did not, would have been a couple $100,000. And yet, the penalties, because they're assessed $5,500 to $11,000 per invoice, per prescription, can amount to $22 million in a case of $200,000 in business. For a corporation with $50 a prescription, for example, a total amount of business around $10 million can result literally in penalties of over $1 billion. That's completely irrational. A similar offense, no different, that has a single invoice issued to the government for the same amount of money would be 11,000. In this other case, $1 billion. It's irrational, and it drives companies to settle frivolous, weak cases, and it should be changed. It doesn't make any sense. There's no other law like it that I'm aware of.
Well, Attorney Ogden, are there cases that we can name in which this kind of extreme result has happened?
There are cases, and I mentioned a couple of them in my testimony, but the very important function is connected to what Mr. Clark correctly said. Frequently what happens is that these penalties are threatened, and a company that actually took a case to trial would suffer them if it lost, but the government settles the case without them, so that you face $1 billion of liability. If you take it to trial and lose, you can settle it for $20 million. Companies do that even if they think the claim is worth nothing, and as would be rational. Now, Dr. Prabhu bravely fought it and won, but other companies don't, and that's not good for the country.
Dr. Harned, where do you stand on this subject?
Congressman, my center is a research organization that is our task and our mission is to better understand how to improve workplace conduct. And so in many ways, the specifics of the legislation and enforcement of it is beyond the scope of what our center's expertise is.
I see. Do you have any further comments, Attorney Clark?
Just one matter. Thank you, sir. Penalties, if a case goes to trial, and I've seen this happen, a judgment can be structured so that if the penalties would amount to more than the Constitution would allow, I've seen judges and attorneys on both sides work those things out so it does not happen that way. But the penalties are important as a deterrent. They are there, and if it's proper to invoke them, they can be invoked.
Mm-hmm. Thank you, gentlemen and lady. My time's expired, and I yield back, Mr. Chairman.
Well, I want to thank, well, I'm so sorry, Mr. Johnson. I didn't mean to look past you, sir. Mr. Johnson.
I'm sorry, I'm just getting to the hearing, just getting a little acclimated here, and I would ask Mr. Clark, well, I would ask Dr. Prabhu, or do you consider yourself to be a free market economic adherent?
No, sir. I'm just a physician.
Yeah.
I'm not a policy expert.
Well,
I
I
just
mean,
Came here
you know the
to
difference
share my
between
experience with you.
you know the difference between a free market and a regulated market. Economics. Perhaps not. Let me move on to Dr. Harned. Do you consider yourself to be a free market person? Or do you believe in government regulations on the economic sector?
Certainly, I do what I do because I am interested in trying to promote productive and effective and ethical business and government and nonprofit organizations. And it is the case that for many organizations, misconduct is a reality, and there should be regulation so that we're able to promote better practice.
Mm-hmm. How about you, Mr. Ogden?
I am certainly a big believer in government regulation. I think it's critical in a free market economy.
Mm-hmm. And Mr. Clark?
Sir, I'm a believer in as big a government as is necessary, but no bigger than necessary. Government has to regulate some things for our safety and to protect itself, but I'm not an advocate of overreaching government regulation.
Mm-hmm. Well, let me ask this question. When we're cutting government in the name of establishing a free market economy, and we are cutting out the ability of government to ferret out fraud, doesn't it follow that private whistleblowers would be consistent with a free market approach to the economy?
Sir, I think whistleblowers are the essence of preserving a free market economy. They look for the things, or they encounter the things that distort a free market, that they look for things that happen, they find things that happen to them, for example, things that they experience on the job that are just not right, that's cheating the government. And that employer, if it's cheating the government, is probably cheating its competitors as well and distorting the market.
So, thank you, Mr. Clark. Mr. Ogden?
On behalf of the Chamber and our proposals here, we support whistleblowers and I totally agree that their function is essential. What we're
But you want to cut down on the economic incentive for whistleblowers to come forward.
We want to preserve the economic incentive for them to come forward. We want to create, along with that, an incentive for their companies to implement state-of-the-art compliance that will protect them when they do report internally, to create increased compliance and self-reporting in addition to the enforcement regime and incentives we have for whistleblowers.
So you would want to limit the whistleblowers and put the fox in charge of securing the chicken coop.
What we would like to do is to ensure that the way entities are operated encourages whistleblowers, protects them to come forward, and we see that compliance programs, here they'd be certified by independent authorities under standards approved by the government. We know that they work to protect internal whistleblowing. And when an internal whistleblower comes forward to the company can stop anything wrong that's happening right away.
Without firing the employee?
Absolutely, without firing the employee.
Well, I tell you, the U.S. Chamber of Commerce now is in favor of cutting government. They're in favor of cutting off access to the courts. And I'm sure that you would agree with me that those are the things that the U.S. Chamber holds dear. And so when we start cutting the ability of a private citizen, or cutting the incentive for a person to put their livelihood on the line to ferret out fraud in a private sector that would create financial disincentives for every other stakeholder involved. I don't see where that, I see that as, I see whistleblowing as being consistent with free market principles, and I find that if there's some inconsistency in terms of, you can't have it one way, you can't have it all. You gotta have, the chamber's gonna have to have some kind of a check and balance. It's gonna either have to have government with the ability, the financial resources to investigate and ferret out fraud, or there's a need for the private whistleblower to come along. And if you don't have either one of those, and you put the fox in charge of the hen house, then we know exactly what's going to happen there. There won't be any fraud ferreted out, and there won't be the free market will be distorted. Competition will be eliminated, and that's just not good for our economy.
Gentleman's time has expired. The witness will be allowed to answer the question.
Thank you, Congressman. Thank you, Mr. Chairman. I hope that Congressman, you'll take a very hard look. I know you already looked at it, but I hope you'll look hard at these proposals. Our goal here really is not to disincentivize whistleblowers. Our goal is to remove fear of retaliation, to ensure that companies protect and encourage whistleblowers to come forward, and to preserve these incentives for them to bring claims where the company hasn't self-reported. And that's really the spirit of these changes, and to make the acts a little more rational so that the things don't happen like happened to Dr. Prabhu.
Thank you, sir.
This concludes today's hearing, and I want to thank all of the witnesses for attending. I know you folks have many things that you have to do, and we appreciate you coming here today. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And again, I thank the witnesses, I thank the members and the audience, and this hearing is adjourned.